Hi, Assalamualaikum and good morning everyone. My name is Muhammad Amir Shukran bin Abdul Aziz. My metric number is 2023731749. Today I want to present to you guys about case of law industry relationship between Muhammad FEROZ Anthony bin Abdullah versus FELDA SAJI Syndrome. I prepared this for Professor Madya Dr. Haji Muhammad Shanawi bin Muhammad Firuz. So now I don't want to waste my time, so I proceed to contents. The first one is fact of the case. I will present fact of the case, and the second one issue of the case, and the third one judgment of the case and analysis and critique. So let's go. So the first one is introduction. This case study explored the dispute between Muhammad Fares Anthony bin Abdullah and Felda di Saji Sindram Berhad regarding the allegations of constructive dismissals. The claimants, a sales executive since 2004, claimed the company breached his contract by mandating 6 months of unpaid leave amid financial struggle during the COVID-19 pandemic. The company argued the leave was voluntary due to the financial constraints. The claimant viewed this as a fundamental breach, leading him to consider himself constructively dismissed. The case highlights key issue of employees' right versus employers' survival during crisis, analyzed under the Industry Relations Act 1967. Now let's go to the fact of the case. So I will summarize this. Has four facts of the case. Number one, the claimant had been employed as a sales executive since 2004, earning RM 4,116 monthly. Number two, on June 17, 2020, the company issued a letter offering voluntary unpaid leave due to financial difficulties caused by pandemic COVID-19. Number three, the claimant viewed this as a breach of his contract and issued a notice of constructive dismissal on July 15, 2020. And last but not least, the company argued that the unpaid leave was voluntary and necessary to sustain its operation during the pandemic. Now we discuss about issue of the case. There has two issues, the key issues for determinations. The first one is, was the claimant constructively dismissed? And number two, if dismissed, was it with or without just cause or excuse? So let's go. The first one, the claimant argued the company fundamentally breached his employment contract by directing him to unpaid leave. Number two, the company contended the unpaid leave was voluntary and necessitated by the economic impact of COVID-19. Now let's go to the judgment of the case. The industry court ruled in favor of the company. Has two. Number one, the claimant failed to prove constructive dismissal on the balance of probabilities. And number two, the company action were justified given the financial constraint caused by the pandemic. Now let's analysis and critique for this case. This case highlight important consideration in constructive dismissal under Industrial Relations Law 1967. Number one is burden of proof. The claimant must prove dismissals and then that employees breached the contract fundamentally. The claimant failure to dispute the company unpaid leave offer immediately weakens his case. Number two for analysis and critique is voluntary versus forced leave. While unpaid leave due to economic challenges can be valid, employer must ensure clarity and fairness in communications. The company demonstrates transparency by informing employees collectively and maintaining certain benefits during unpaid leave. Number three is impact of COVID-19. The unprecedented pandemic justified measures such as cost reductions to sustain operations, and the company showed reasonable effort to address financial challenges while keeping employees informed. So for the critic, the Cleveland delay response and lack of immediate protest undermine his claim. And the second one, the company reliance on the pandemic as a reason was justified by better communication of alternative example, mutual agreement might have avoided dispute. So we have three in this analysis and critique: strengths, weaknesses, and critique. For the strengths, the court applied the principle of the balance of probabilities effectively. For the weaknesses, the voluntariness of the unpaid offer could have been better communications to employees. And for the critic, this case demonstrates the importance of clear communication and mutual understanding between employers and employees, especially during crises. Employers must ensure that measures like unpaid leave are well documented, and consensual to avoid dispute. So I can summarize the conclusion. In conclusions, this case highlight the challenges of balancing employers and employees' right during unprecedented event like the COVID-19 pandemic. While the company acts within its financial capacities, a more transparent process could have prevented this dispute. As a takeaway, as a takeaway, this case reinforces the need for proactive communications and equitable treatment in industrial relations. So before I end my discussions and these videos, I want to give one quote for this case. Employees should not be forced to choose between their livelihoods and their dignity. So thank you everyone for listening my presentation, and thank you Prof. Assalamualaikum. Don't forget to subscribe, and bye everyone.